Conservatorship in Texas. That's the word that courts use and the Texas Family Code uses in talking about making legal decisions with regard to your children. And generally, in Texas, it's presumed to be in the best interest of the child for parents to be joint managing conservators. That's conservatorship. And what that does is give both parents the right to make decisions about the health, well-being, safety of the children. And it comes up in terms of psychological decisions, like whether a child needs to see a therapist or be on some sort of, psychiatric medication. Medical decisions like healthcare, do they need to get their tonsils out? Do we want to do this elective procedure? And then education-based decisions. Should the child receive special services from education departments at schools, or should they take AP courses, things like that? So conservatorship in Texas is a very significant part of your Texas divorce or custody case. Possession and access schedules in your Texas divorce or custody case will come up in terms of how each parent will spend time with the children of the marriage. And normally in Texas, you're going to see things like the expanded standard possession schedule. That's the default parenting plan that's presumed to be in the best interest of the children in your Texas divorce. Now, parents can agree to some other plan if that's what they want to do. And you're only limited by your own creativity and cooperation and that of your lawyer. Some people do things like week on, week off, or 2-2-3, where they alternate when the kids will spend Monday, Tuesday with one parent, Wednesday, Thursday with another parent, and then alternate their weekends. And it really depends what is best for you and your family and your kids. And you know best. And the way you can try to have some control on how the schedule will be awarded is through mediation. Because if you go to court, a court is much less likely and almost would venture to say unlikely to enter things like a 2-2-3 sort of schedule. If you want that, your best chance for that sort of a possession schedule would be in a mediation, because a court is most likely to enter some version of an expanded standard possession schedule in your Texas divorce or custody case. Texas deals with conservatorship of children when it comes to the legal decision-making rights parents have about their children. There's this presumption, read assumption, that it's in the best interest of the children for parents to be joint managing conservators. That's where they have equal rights to make these decisions about the children's psychological, medical, and education, decisions in their life. Now, sometimes it's appropriate that parents are not joint managing conservators, and one parent may get sole conservatorship or sole custody. Here's the thing, it's pretty uncommon for that to happen because Texas has this idea from the legislature and in the Texas Family Code that children do better. Their best interest is served when they have robust, involved parents in their life. And so to go against that and to change it and to say, no, only one parent can make these certain decisions about the kid or the children, something probably pretty bad or wrong is going to have gone on, because that sort of kicks one parent out of the decision-making process and allows only one party to say what's best for the child as it concerns like medical decisions, psychological decisions, and school decisions. So it's presumed to be joint. Sole may be an option, but it's unlikely unless there's some pretty bad facts in your situation. You're going to need to talk with a lawyer about the potential viability of sole custody in your situation, because it's really fact specific depending on your case. Texas has a weird function in family law about a child's primary residence. And don't beat yourself up if you've read stuff online and you feel a little bit confused, because the way the Office of the Attorney General and the code and lawyers and regular folks talk about primary parents varies, and it's different depending on who you're talking to. But here's the thing. In Texas family law, the way it works out is one parent is going to have, or should in most circumstances have, the right to determine the primary residence of the children. And that parent is the one who is usually entitled to receive child support and usually entitled to not have to pay the health insurance premiums. But here's the thing, the word primary is associated with the primary residence. And that just means this parent is going to say where the kids live primarily. And then they go do visits with the other parent. And you may say, hey, why does it matter if I determine the primary residence? Like one of those things, like we just talked about, is because of child support. The other thing is the default expanded standard possession schedule gives more possession time or parenting time to the parent who has that right to determine the primary residence. So it's a pretty key fact in your custody case who gets to determine the primary residence of the children. So you want to proceed carefully and understand how that designation will play out in your divorce or custody case.